everybody, and welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the network, where we cover the most interesting live trials and legal stories in the news today. And as always, we have a lot to cover, so let's get started right now. First up, I want to talk to you about our live trials of the day, and the first one that we're waiting to go live, and I'm looking at the courtroom feed, is out of New Jersey, and it is the Jeremiah Monell case. We're going to be back live in that courtroom. We weren't live yesterday. Court was dark yesterday, and what an explosive day of testimony from last week. Now, you might remember that Jeremiah Monell is charged with the brutal murder of his wife, and who is soon to be his ex-wife, Tara O'Shea Watson. She was stabbed multiple times. Prosecutors say at least 48 times in her home, in the kitchen. And do you know who witnessed this? The couple's 12-year-old son. Well, he's 14 years old now. He was 12 years old at the time of the attack. And he took the stand last week and testified against his father. It was pretty incredible to watch, and also equally heartbreaking. We're expecting to be live in that courtroom any minute, so as soon as we have a feed, we're going to make sure to go there. I do want to let you know about another trial that we're going to be live in later on in the afternoon, and of course, that is the McStay family murder case out of California. Charles Merritt is on trial for the murder of an entire family, and he's accused of brutally killing them in 2010 through the use of a sledgehammer, and then burying their bodies in 2 shallow graves in the Mojave Desert. The remains were discovered 3 years later. Prosecutors have alleged that this was a financial motivated crime, but the defense is saying they have the wrong man, the state, that they are prosecuting the wrong guy, that there is another person who should be looked at, that a man named Dan Cavanaugh, another business associate of Joseph McStay, one of the victims, is really the killer. Very interesting case, and yesterday was a really compelling day of testimony where the prosecution seemed to present the case that the killings occurred in the McStay family home. There's a lot to talk about there, and again, we will talk more about it a little bit later on in the program. Right now, though, let's focus on the Jeremiah Monell case because we expect to be live there any moment. And let's start right now with Detective Michael Hughes from the New Jersey State Police Department. In case you haven't seen any of this testimony, let's start right there.
What was the appliance that was located directly behind where those bloodstains were located?
There was a stove there.
I'm going to approach you with S113 for identification. Do you recognize what's depicted in S113?
Yes, that's the kitchen stove.
And does that accurately represent the area where you also searched?
Yes.
Why did you search behind the stove?
Just as part of our search of the residence, we check all areas, and when we pulled the stove out, we observed items of evidence behind the stove.
And what did you observe behind the stove?
2 knives with suspected blood.
I'm going to show you S114 for identification. Do you recognize what's depicted in S114?
Yes, that's a view of the stove pulled out, looking down at the floor below, beneath,
and does that
the stove.
I'm sorry. Does that accurately represent the location of the knives when they were discovered?
Yes.
And I'll show you S115. Do you recognize what's depicted in S115?
Yes.
And what is that?
It's a close-up of Exhibit S114. It's the knives on the floor behind the stove.
Again, does that accurately represent the location of the knives when they were discovered and later collected as evidence?
Yes.
Then I'm going to move on to S116. You recognize what's depicted in S116?
Yes.
And what is that?
There were two knives behind the stove. One was larger and one was smaller. This is a view of the larger knife.
And that's a photograph of the knife after it was collected?
As it was being collected, it was removed from the floor. It was placed on brown paper and photographed.
This next is going to show you S117. Do you recognize what's depicted in S117?
Yes.
And what is that?
That's the same knife. That's the larger knife.
And does that also accurately represent a photograph of the knife after it was collected?
Yes.
And is there any other item of that is within that photograph?
There's just one knife in the photograph.
What about something to help reference the size of the knife?
Yes, there's a scale.
And now I'm going to show you S118. What's depicted in S118?
That's the smaller knife that was behind the kitchen stove.
And also S119?
Yes, again, that's the smaller knife. That's the opposite side of it.
And S116, 117, 118, and 119, do these accurately represent or depict the knives after that they were collected by yourself?
Yes.
Judge, I would ask that S113 through S119 be admitted as evidence?
Objection.
Okay, confused. What is depicted on the screen at this time?
This is a view of the stove in the kitchen.
That was S113?
I don't recall the number, sir.
Or is it S113?
Yes, S113.
Thanks. Move on to S114. Again, what is that there?
This is a view of the stove pulled out, looking down at the ground behind the stove, and there's two silver knives with suspected blood behind the stove.
S115?
This is a close-up of those same two knives with suspected blood.
S116?
This is a view of the larger knife with the suspected blood stain, and you can see the damage to the knife as the blade portion of it is bent and in sort of a U shape.
S117.
That's a view of the opposite side of the knife, the larger knife.
S118?
This is the smaller knife with the suspected blood, and it had damage to the front tip portion of it, which was bent.
S119?
And that's the opposite side of the smaller knife.
Okay, let's break down some of the Jeremiah Monell case in anticipation of our live feed. Joining me right now is criminal defense attorney Michael Bachner. Michael, good to see you, and I'm glad we get a chance to talk about Monell before it starts up. One of the most interesting aspects of this case is, as the prosecution keeps putting forward their case, they seem to have a pretty strong, a lot of evidence against this man. He rejected a 30-year plea deal, and now he faces life in prison without the possibility of parole if he's convicted. We saw his son, Jeremiah Monell Jr., testify last week and provided extremely compelling testimony against his father. Were you surprised that such a deal was rejected?
I am, but having been in this business long enough, I know that happens. I represented a 19-year-old from New Jersey who was alleged to have been involved in organized crime, who killed 8 people and at the age of 19. And he was offered a 37-year plea, which would, under the federal guidelines, would have let him out after about 30 years. He rejected it, and his statement, his position kind of was, I don't live in jail for 30 years. In other words, I'm not going to make it anyway. So I might as well roll the dice, and 30 years to me is the same as a life sentence. So that's kind of probably what was going on in this fellow's mind. We call this long guilty pleas, these trials.
Right.
They're just inevitable.
Yeah, and we're going through it, and he put his son through it to testify against him. It's pretty incredible. Now, talking about the discovery of the body, we should note that this young man is not the only one who discussed the discovery of the body. We saw the testimony of Glenn Akinson Jr., who's a paramedic and the victim's neighbor. Take a look at what he had to say about discovering the body of Tara O'Shea Watson.
Once he got inside, what happened after that?
He opened the front door, and that's when I entered the residence. I looked around and didn't see anything out of place. I looked down, and the only thing that caught my eye out of place was there was Sarah's comforter laying on the living room floor.
And what did you think when you saw that comforter?
From my past experiences, I didn't think anything good could come of it.
Once you saw that blanket on the floor, the comforter on the floor, what did you then do?
I then went to the upper right-hand corner, raised it just enough to where I could look in. What I saw was Miss Dyer's head was turned to the right. I saw minimal blood splatter up the side of her cheek. Eyes wide open, mouth wide open. Skin was pale, cold to the touch. Went to move the jaw and it wouldn't move. I went to reach for a pulse in the carotid area, and my finger went into a gaping hole. I immediately pulled the blanket back, told Jimmy to exit the residence, and Jimmy had been looking over my shoulder. He was on the phone with the 911 dispatcher. He dropped me the phone, and he went and exited the residence as he came in. I told the dispatcher what we had. I asked for a BLS and an ALS ambulance to respond to the scene, to do a pronouncement. Also asked for the crime scene unit and told them I was securing the residence and declaring it a crime scene until they could get there.
Wow. So you're just listening to more testimony about the discovery of Tara O'Shea Watson's brutalized body. But again, this was not the only person who testified about this. We also saw Detective Matthew Hamlin from the New Jersey State Police also describing the scene. Take a look.
You enter the residence. What did you observe?
When I opened the door, I immediately saw a multicolored, predominantly pink blanket in front of me with what I believe to be a human body underneath it. The door wouldn't open all the way due to it hitting the right foot of the deceased. Me and Trooper Blair entered the residence. Two uniformed troopers entered to clear the back of the residence. And at that point, I kneeled down, lifted the blanket, and observed the deceased white female, approximately at that time, the age of early 30s, with multiple stab wounds to the abdomen, chest, and neck, to see if there was any medical aid I could render. But it was pretty obvious that she was deceased.
Once you made those observations and determined that the person was deceased, what was the next step that you took?
The two troopers that we sent down to make sure there was no additional people in the residence told us it was all clear. I instructed them to exit the residence. Trooper Blair exited, and then I exited last, securing the front door.
Once you exited the residence, did you contact anybody?
I contacted our operational dispatch unit, which is our dispatchers, told them that we did have a homicide and to make contact with the appropriate units in the state police, the homicide unit south, crime scene, and medical examiner's office.
Just a horrific crime scene, and never easy to hear in any case, let alone this one. Michael, though, if this man really did do this, okay, if Jeremiah Monell really did do this, is this just another example of domestic violence crimes gone bad? And really, how could you have prevented this from happening?
Well, when people in these types of disputes seek restraining orders, spouses seek restraining orders, that is oftentimes an enormous red flag, and we know that from the infamous O.J. case where Nicole had sought restraining orders, had been beaten up in several occasions, and people ignored that stuff. And that's why, interestingly, in New York, for example, on a domestic violence complaint now, the defendant in that case is taken into custody and must spend the night in jail. They used to be given what are known desk appearance tickets to release them and just come back in a few hours. And everyone is very concerned about the ignoring of these types of flags. But this was such an angry crime that was allegedly committed. The number of stab wounds. And interestingly, sometimes in these domestic violence cases, the spouse is like, well, if I can't have the children, you can't have them either, and he kills everybody, and then himself at times. This is the spouse, and let the child live, and it's just a crime of enormous, enormous anger.
But does there need to be a change in the laws? For instance, if there was how much does a restraining order actually prevent this from happening? We saw another case, the James Colley case out of Florida. Restraining order didn't stop that guy from going on a shooting rampage and killing, his ex-wife. So, I mean, is there a way to prevent this from happening and say, hey, listen, we need police out at a certain point to just check up on this if people are in the middle of a divorce proceeding? Because then I would assume the counter-argument is, let people live their lives. You can't jump into every disagreement.
That's exactly the point. There's a limit to how much you can expect from law enforcement. Can you imagine the amount of manpower, people power that would be required to have to monitor people like this? I mean, there could be an argument made that there have to be call-ins quite frequently. Maybe they have to seek psychiatric or therapeutic treatment during it and having report-ins, but
it's no easy answer, and there's no easy answer about why this happened. Again, we're still going to continue our coverage of this case. As soon as we have the live feed, we're going to make sure to go there. But we're going to take a break now. When we come back, we are going to play you the testimony of Jeremiah Monell Jr. Stay tuned. Okay, Michael, you made a great point. We were just talking about it, the idea that he could have taken a plea deal, Jeremiah Monell. He didn't have to put his son through this, testifying about this horrifically savage event that clearly has traumatic effects. But he forced his son to do this. I mean, what do you make of this?
It's an indication of, it's kind of killing the mother again, making the son go through the events and seeing it again. It's a real sign of just the anger that the defendant apparently appears to be having again towards the family, towards the wife, to reliving this thing in court, the pictures, the weapons. It's just further indications of his mental state. And again, the anger he must have towards the son and et cetera. You know, in dealing with a child witness like this, you know you're not going to convince a jury the child's lying. That's impossible, or that he's mistaken. So the only effort you can do is try and get from him information that could be helpful for the defendant in getting a reduced sentence. And that would be to try and get the son to acknowledge that dad was crazy, that dad didn't act right. He was under some extreme emotional disturbance, to try and get some reduction in the sentence, or to get a reduced conviction. But to put your child through this, and that's why the offer was made to him at 30-year cap, was because the prosecution didn't want to put the kid through this. It's the reason why in rape cases or in these types of offenses, prosecutors will often try and strike a deal. It's not because they're afraid to try the case. It's to try and keep the victim from going through it and being traumatized the second time. But this is just an indication. And if I'm a juror, boy, I'm thinking, this is really something.
And you know, Michael, that we've seen a lot of times where defendants midway through the trial have said, hey, I don't want to fight anymore on this. Maybe I'll plead guilty to something. I don't want to put the family through this anymore. So, I mean, everybody's entitled to a defense, but at the same point, having your son testify, it's just not fair. Let's have a little bit more of Jeremiah Monell Jr. when he took the stand from last week, in case you haven't seen it.
After you looked away, what did you do?
I climbed in my bed.
And what did you do after you climbed in your bed?
I went under my blanket and started crying.
And what's the next thing you remember after you went under your blankets?
I looked back and moved the curtain a little bit, and I saw my dad. He was smoking.
What kind of cigarettes did your dad smoke?
Marlboro, Menthol.
And what's the next thing you remember after he was smoking a cigarette?
He walked to my room because he heard something, and he saw me awake, and then he started saying, "You should not be awake. You saw it."
Rejection.
What's rejection? Jeremiah, again, what did you hear your father say when he came back into your room?
He said, "You saw it," and he was saying, "You shouldn't have saw it."
Did you say anything to your dad?
I said, "You killed her," and I said that a few times.
What did your dad say after you said that to him?
He said, "You should not saw it."
What's the next thing that happened after that?
He told me to go to sleep.
And did you go to sleep?
I just went under my blanket and still cried.
Do you remember seeing your father again that night in your room?
Yes. He woke me up and told me, to go out the back door, and that you're probably going to go with your aunt and uncle, or aunt or uncle.
Do you know what aunt or uncle he was talking about?
Yeah.
Who?
Actually, more descriptive, he said, you're going to go with Uncle Josh or Uncle Eddie.
And who are they?
Edward John Monell and Joshua Monell.
Okay, so he took the stand. Clearly, this is not a fair thing to do to him, right? But the defense, when they went on and cross-examined him, they didn't really get much. Yeah, they questioned him a little bit about timeline, but okay, what was the point of this? I mean, yeah, it was such a strong witness to show that he placed his father as the person who did this. What did the defense gain? What did the defense was able to get out from him at all? Just a timeline? I mean, they weren't really able to do much with this witness, correct?
Yeah, these are one of we call bulletproof witnesses that you've got to be very, very careful with, especially a child victim witness or any alleged victim where you're not alleging that they're lying. You've got to be very, very careful. Now, look, the defendant has always been raising ineffective assistance of counsel claims prior to the trial. He's been saying that he's been very unhappy with the legal representation he's been getting, that they're not on his side, they're not doing the right thing. He may at the end of the day say that his lawyer was wholly inept and wholly ineffective, and he needs a new trial. But there's nothing that the lawyer did that was effective in this.
That's a good point. Okay, I'll tell you what we're going to do. Let's take a break. When we come back, we may be live in the Jeremiah Monell case out of New Jersey. We'll be right back right after this. All right, some evidence is going to be analyzed. We're going to see the DNA matches. Now, Michael, I believe we're getting reports that the prosecution's case may wind up today, may wrap up. The defense, since they really in their opening statement weren't entirely clear which way they're moving, can they change paths and say, hey, we're going to go with an entirely different defense here? Maybe, as you said, bring in some experts to describe emotional disturbances?
They can certainly change their paths any way they want. Their opening statement, as I understand it, was rather open-ended and not really very directed or specific as to what they thought would they'd be arguing in the case. So sure they can. There may be some issues regarding notice in a criminal case about the use of expert testimony. That is, whether or not they should have given the prosecution notice of it so the prosecutor would have the chance to get their own expert if they were going to argue psychiatric or emotional types of issues. So that could be an issue down the road if they decide to throw that in out of left field. But given the nature of this case and the seriousness of it, the judge may let it in.
Okay, well, I'll tell you what. Let's take a break because some evidence is being analyzed. We'll be right back right after this. Stay tuned. All right. Now, Michael, you had made an interesting point about this witness, that with the incredible testimony of Jeremiah Monell Jr., is it even necessary to keep putting forward these witnesses to show what DNA evidence is there, again, trying to prove their case? But isn't it their burden to keep proving their case?
It is, and I guess a viewer might be wondering, given the nature of this rather strong child testimony, why are we bothering with all this kind of scientific, tedious stuff? The answer is prosecution has the burden of proof beyond a reasonable doubt, and they try to leave nothing to doubt. And you can imagine if they didn't do this, the defense lawyer on summation may say, ladies and gentlemen, sure, they had this kid testify, but shouldn't the government have done X, Y, and Z? Why didn't they do X, Y, and Z? So they're just locking in that we're avoiding that argument.
Right. And what's interesting to note, too, is an expert can only go so far. So she's a body fluid expert, can talk about the presence of the body fluid, but perhaps this witness who just got on the stand will tell Chapter 2 of this DNA analysis. Let's see what she has to say. Okay, so I keep thinking about where the defense is going to go here, and I don't know. I don't know if you had a chance to see the opening statement, but really what they said to the jury was, I want you to keep an open mind, listen to each witness. Are they giving you answers? And I'm still curious about which way they're going to go, because they did take this to trial. But really, that decision's up to Jeremiah Monell. Have you ever had a client who says, hey, listen, I know we don't have a really good case. I don't really care. Just fight it out. Do whatever you can. And really, there's no strategy moving forward?
I try to avoid the no strategy line, but if I have a client who's going to be adamant on going forward on a case that I perceive to be what we call a long guilty plea until the jury's going to convict, you do have to have a strategy, because you know what? You never know. A defense lawyer only needs one juror to be unconvinced to have a hung jury. So you do have to have a focus and a strategy. And in me, this strategy would be that Dad was nuts.
You know, some of the items of evidence which we're talking about were really incriminating. That bent knife, the knife was actually bent and it was hidden behind the stove. Or let me rephrase, it was found behind the stove, the two knives. What did you make of that?
Well, it certainly goes to some level of premeditation, arguably, that there was an effort to cover up the offense. Certainly the fleeing was more evidence of premeditation. So the fact that these things are hidden obviously goes towards that. The other argument is that it also indicates that there was an effort being made by whoever did these homicides to try and delay a capture and delay the finding of evidence. So it does go to premeditation.
And just the bent knife, the level of force and
anger,
aggression,
sure,
just
absolutely
incredible. Now, Michael, stand by. We're going to take a break. When we come back, we're going to be live in this courtroom. And again, we're all waiting to see what the defense will do. So stay tuned here on Law and Crime. We'll be right back. let's break this down a little bit more with criminal defense attorney Michael Bachner. He's back with us right now. This is a really sad case, and we talked about it a little bit more. I want us to talk about it a little bit more now. How often do you see these crimes, and again, if Jeremiah Monell is the one who did it, happening in the home of the victim, you know, these domestic violence crimes, and maybe even particularly the kitchen? Again, we're talking about kitchen knives being used as the murder weapons. That's why they're so bent. They're not meant to be used in this fashion. How often do you see these kinds of attacks happening in these areas?
Well, you know, I think historically you would find that that's probably usually where they do occur. Domestic violence cases are by definition domestic, and domestic usually means certainly the connotation is the home. That's where people are close together in a confined quarters, and that's oftentimes where arguments arise, even in normal homes where you just have disputes or arguments with your spouse. Oftentimes you're together and something heats up, and generally when you're in an area where there are weapons, and that's knives, it's a very bad place to be where someone's got a temper.
Now, I got to ask you one more question before we jump live. One of the interesting aspects that we heard from Jeremiah Monell Jr. is that there was a pause. So the way it hears is there was an interaction, there was an altercation between Mr. Monell and Tara O'Shea Watson. Let's say it was physical. She then makes the statement, according to the son, please let me die in peace. It's at that point he then retrieves the knives and kills her. That period in time, correct me if I'm wrong, does that determine the level of culpability because of that pause?
Well, you know, that's a very interesting question. A judge will instruct this jury, the general instruction on intent, that is what a jury must find to find that a crime was committed with what lawyers call mens rea, or the intention to commit a crime, can be created in a split second. So there's no time level premeditation, but certainly that lapse in time demonstrates you're responding to a command in a very premeditated fashion.
Okay, we'll talk more about it. Let's jump back live into the courtroom right now. Okay, is any of this surprising to you, Michael, that his DNA would be there, her DNA would be there? Again, we talk about the idea of how valuable is this testimony. Do you believe that this is going to be the last thing the prosecution wants to put forward in the minds of the jury? Because they can structure who they want the witnesses to be. Wouldn't this testimony have been more powerful in the beginning and then end with Jeremiah Monell Jr.?
Yeah, frankly, that's probably how I would have done that. But you did want, I think, maybe the son to just let that testimony just kind of foment in their minds. But you know, this DNA testimony is oftentimes introduced not so much even to show that it matches the defendant, but it is to exclude anyone else. So in other words, they're trying to show that we didn't find anyone else's DNA here, only the people who you would expect to be there and who we've charged. There's no other intruder.
Because we don't really know what their defense is. I mean, that's the thing. Do you think they have to put Jeremiah Monell Sr. on the stand, the defendant, to explain what happened? Because I'm not sure what else they can do except maybe calling some expert witnesses to talk about emotional disturbance like you explained. Yeah,
look, it seems to me from everything I've seen and read that he actually is putting forth the defense of I didn't do it. So if he wants to take the stand just to rant, and it's his right to do that, and to get on there or not get on there, I guess he can. It doesn't seem to me that it can get much worse. But you know, it'll be interesting to see if they don't put on any kind of defense. I still think that there could be some bordering on whether there's going to be an ineffective assistance of counsel claim like down the road. There was no preparation for my defense. They didn't interview people. I want a new trial. Then he gets a new trial, and who knows down the road what happens.
But the attorneys couldn't agree to that.
Couldn't agree to...
if that was his plan to say, hey, I want a new trial.
No.
So...
I'm wondering, he's laid this foundation. He has said in previous matters that the lawyer is ineffective. She's not, or he or she is not doing the job. And now if we do go into a trial and there is no expert, there is no thought putting forward here, there's no cross-examination of my son, you know, what's the defense here? An appellate court may say that, you know what, this was ineffective, or they may say the evidence was kind of overwhelming, it doesn't matter. But
it's hard to read.
You never know.
You never know, and it's hard to read anything from Jeremiah Monell. He's very stoic as he sits there in the courtroom. Let's take a quick break. When we come back, we'll be live in the courtroom. Okay, Michael, what do we get from this? I mean, the idea of trying to question that the defendant, the victim's DNA was excluded from some of the items of evidence, the partially burned cigarettes, saying that his DNA was not on certain items of evidence. Is this so valuable? Because even if you say his DNA is found nowhere, does that mean the defense can show that he's not the one who did this?
Well, if the theory is going to be that the son was either under some type of trauma or that the son was making it up because he hated his father, whatever it may be, the fact that DNA is not found where you would expect it to be found based upon the nature of his testimony, then maybe that raises some issue in a juror's mind about, oh, that's kind of weird. Why isn't the DNA there? We used to call DNA back in the old days do not acquit evidence because once you got that, it's a hard out. But juries have been acquitting despite DNA evidence. There was a recent acquittal here in New York on a charge despite DNA.
I suppose in this kind of case, what is reasonable doubt?
Well, reasonable doubt is a doubt that causes a reasonable person to hesitate in matters of everyday life, to cause it. The judge will tell the jury it's not a scientific certainty, it's not a mathematical certainty, there's no such thing as that in life. It's just something that would cause them to hesitate in matters of everyday life. The fact that DNA may not be in a certain location probably is explainable regardless, even consistently with the son's testimony. So I don't think this is really much of a big deal. My view of the world is they would have been better off trying to reduce his exposure and admit the conduct than to try and say he didn't do it.
You mean say, hey, listen, yes, he did this, but this isn't murder. He was in a fit of rage. This is manslaughter. Is that what you're trying to say?
Correct. I mean, the son was not there when the argument began. So the son could not give any testimony as to what could have induced the anger, what could have caused this to happen. So that would have been an opening for an expert to say, I interviewed the defendant and this is what caused this. This was an irrational outburst of conduct, and the nature of the stabs and the level of force used to bend that knife is indicative of somebody who was really just wholly out of control. And at the time that he put that final knife wound into her at the end, she was already gone.
There's no question about how savage this was. Cross is continuing of this witness. Let's go live. Michael, did we get anything new from the conclusion of this witness? Again, it's all about DNA right now.
Yeah, the witness basically said while he was not everywhere in the 16 points that they look at, which are really the indicative parts of DNA, which is very interesting. People have a lot of DNA that kind of matches everybody, but there are certain areas that don't match everybody, and Jeremiah Monell was found to be in a minor contributor on certain of those locations. So long as her testimony does not impeach or is not significantly inconsistent with what the son said, then I don't think the defense has scored any points.
I wonder if you just say, hey, we can prove he was in the house that night. That's all that matters. It doesn't matter if his DNA is on the knife, the pants, doesn't really matter. As long as he's in that house, and we got Jeremiah Monell Jr.'s testimony, that's all that matters.
Yeah, I think that's ultimately this case is going to be about the son and whether they believe the son. If they believe what he said, the DNA is going to be corroborative at best for the prosecution and inconsequential at worst.
The thing that keeps striking my mind is when you said he might be able to mount a successful ineffective assistance of counsel claim, basically saying his attorneys didn't do a good enough job and he deserves a new trial. It doesn't matter what happens here. That's still sticking in my mind. I can't believe that that's an actual possibility.
Yeah, I mean, what's going to happen is once he's convicted, if that does happen, he'll get an appellate lawyer. And the appellate lawyer is going to look at this transcript and say, okay, what can we argue? And they're going to look at this and say, well, the evidence was very strong, but what is it that the defense lawyer did to mount the defense? Well, the cross-examination of the son was essentially non-existent. There was no strategy. There was no focus other than he didn't do it. Now, look, if the defense was smart, they would have confirmed in writing privately with the defendant that our recommendation is you propose the following types of defenses, and if his position was no, this is my life, the defense is I didn't do it, then the defense lawyer said, hey, I only could work with what I could work with. But if there isn't such cover your tush type of memorandum to the file, it ultimately may be that someone's going to look at this and say, hey, you know what, there's no defense here, they should have argued the following.
Let's just make it clear, though, for all of our viewers. Arguing a successful ineffective assistance of counsel claim, that's tough, right?
Very tough.
Yep. Okay, so let's take a break. When we come back, we'll hopefully be live in that courtroom, and if we're not, we have a lot more to analyze. Stay tuned here on Law and Crime. We'll be right back. Okay, so Michael, it's never easy seeing this testimony, especially from family and friends that knew the loved one. But to just be this person for a minute who knew Tara O'Shea Watson, said like a brother to her, and to discover the body, what do you think that's like?
Well, you know, having dealt in these types of cases, it's something you obviously never forget. It's something that lives with you forever. It's a massive, generally a massive type of trauma that's the horrible parts of these crimes. They live on. They really never go away. Especially for Jeremiah Monell Jr., 12 years old when he discovered the body of his mother. Yeah, he will be unfortunately, in a therapeutic type of situation probably for the rest of his life. Not only the loss of the mother, but the loss of the father, and the father being the perpetrator of the crime. There'll be trust issues forever. It's horrible. I think cross-examination has started. Let's go back live. Okay, so that was quick right there. Really didn't gain that much more. I guess, is it tough to cross-examine these kinds of witnesses? What kind of information are you trying to get? I think there's timeline issues. You may be trying to figure out if there's a way of arguing that Monell wasn't there at the time and bring some inconsistent issues. You know, you and I discussed earlier, one of the things that I think that this defense lawyer may have missed is when this witness volunteered that there was a restraining order out there, which the judge immediately admonished the jury to disregard. Again, a defense lawyer's job at that point would have been, in my opinion, to move for a mistrial. That is to say, Judge, this is so irreparably problematic for the defense, we need a new trial. We've got to start all over again. And the judge would have denied that motion, but that's something to be argued later on appeal. I want to talk more about that, but let's take a quick break. When we come back, we'll either be live in that courtroom or we're going to talk more about a lot of the details in this case. So stay tuned here on Law and Crime. We'll be right back. Michael, it just doesn't get easier to listen to that. How do you prepare this witness? If you're working for the state, we want to call you. How do you properly prepare him to testify in open court? And also, you could say around the world, because we're broadcasting this, for everyone to hear his story. Well, one of the things you do with a witness like this is let them understand that really they're only speaking to the juror, the judge, and you. The idea of them speaking to a larger audience is probably somewhat detrimental to them. You also want to just get an emotional, kind of like a little test for them, a little bit of a litmus test. How are they doing? Are they somebody who can actually relay this, or are they going to break down? You're probably speaking to a therapist, if he has one, to see how that person's doing. And you're trying to just see how he's going to come across. Is he going to come across as very matter of fact, as this witness does? Is he going to be a crying witness? Is he going to be a very emotional witness? And, you know, the very kind of the lack of any affect that this witness has, he's not a very emotional witness, I think is just part of the harm that he's suffered here. The only way he really can deal with this, it seems to me, is telling the story in a matter-of-fact way, kind of external to himself. You've seen this before? This is what, where witnesses kind of, it's an out-of-body experience. You're relaying things that you saw, but not as you actually are the person seeing them, because that's the only way you can deal with it, by telling the story as if they're telling it as a story, as something you've seen, but not really that you've experienced. And can you imagine the impact of having, and you and I spoke about, not only seeing it, but living with your dad's name, you being, it's just, the impact on this young man is just horrible, and that's the emotional toil of actually making this kid go through this again. And something you and I just will never understand about what's going on in his mind, and it's just incredible to listen to. Let's play some more of his testimony from last week. Okay, back here with Michael Bachner. This testimony from last week. We're trying to see what the defense will do. They're in a 15-minute break right now. Not sure which way the prosecution is going to go, how much more the prosecution actually has to put on their case. What do you think the defense is thinking? Because then the case is handed over to them, and we're watching really incriminating testimony against their client. Yeah, we're not aware of them having given any notice to the prosecution or the court of calling an expert witness. They may or may not call one, so we're not anticipating that's going to happen. no alibi that we're aware of, because they would have to give the prosecution note of an alibi defense.
In other words, there's no surprise attacks here.
Yeah, I don't see any surprises or non-surprises. I don't know if the defense, 99% of the time, defendants put on no case at all because they rely on the burdens of proof. So that may be happening here. I think the only thing that could possibly happen is Jeremiah Monell taking the stand, thinking I've got nothing to lose, and trying to tell a story of some kind.
But he has a lot to lose, doesn't he?
Well, he's going to get convicted, I think, he thinks anyway, and go away for the rest of his life. So,
but if he testifies, can that help him in the sentencing phase at all?
Not if he goes up there and tells a story that I didn't do it and everyone's lying about me. And if he gets on there just to acknowledge his responsibility, he might as well have taken the 30-year plea and tried to get the judge to go less than 30. There was a cap of 30. The judge could have done better.
Right. So, Michael, last question. What do we expect moving forward today?
I'm expecting the prosecution's going to rest, and if there's no defense, I would anticipate the jury's not going to be deliberating that long. But I've seen crazier things.
I've seen different things happen, and we never know which way it's going to go. We'll have to see what the defense does. Michael Bachner, thank you so much for coming on today. I appreciate it. Sure. Okay, everybody, we're going to take a break on our end, but when we come back, we might be live in that courtroom. I'm keeping a very careful eye on that feed. We don't want you to miss anything in the Jeremiah Monell case out of New Jersey. So you know what I'm going to say. Stay tuned here on Law and Crime. We'll be right back. We'll be right back right after this.